Meaning and definition of international law. Origin of the term. The term international law was first used by Jeremy Bentham in 1780. It refers to a body of rules and principles which regulate relations among members of the international community. Earlier, the international community consisted only of states, but today it includes states, international organizations, individuals, certain non-state entities. Oppenheim's definition. Professor L. Oppenheim, 1905, defined international law as the law of nations, or international law is the name for the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. Importance. This is one of the most classical and authoritative definitions. It emphasized customary and conventional rules. It treated states as the only subjects of international law. Criticism of Oppenheim's definition. Oppenheim's definition is now considered obsolete and inadequate due to changes in international law. Criticism of Oppenheim's definition. Oppenheim's definition is now considered obsolete and inadequate due to changes in international law. Major criticisms. States are not the only subjects. Earlier, states were considered the only subjects of international law. According to traditional writers like Oppenheim, only states could possess rights and duties under international law. However, with the development of international law, this view has changed. Today, it is universally recognized that states are not the only subjects of international law. International organizations also have rights and duties. Confirmed by the ICJ Advisory Opinion, 1949. Reparation for injuries suffered in the service of the UN. Individuals have limited rights and duties. Individuals now enjoy certain rights and duties under international law. Human rights law grants rights to individuals. International criminal law imposes duties and liability on individuals for crimes like genocide, war crimes, and crimes against humanity. Individuals can be punished directly under international law. Sources of international law ignored. International law is not limited to custom and treaties. General principles of law are also sources. Recognized under Article 38 of the ICJ Statute. Other non-state entities, certain territorial or political entities, though not states, have limited rights and duties. Examples include national liberation movements, trust territories. Changing nature of international law. International law has evolved from a state-centric system to a community-oriented system. The term international community now includes states, organizations, individuals, and other entities. Fenwick's definition. Modern view. Fenwick defined international law as the body of general principles and specific rules which are binding upon the members of the international community in their mutual relations. Merits. Uses the term international community. Includes states, international organizations, individuals, other entities. Recognizes general principles of law. Revised definition in latest edition of Oppenheim, 1992. Editors Sir Robert Jennings and Sir Arthur Watts revised Oppenheim's definition. International law is the body of rules which are legally binding on states in their intercourse with each other. These rules primarily govern relations of states, but states are not the only subjects. International organizations and, to some extent, individuals may also be subjects of rights and duties under international law. Evaluation. More comprehensive than the earlier definition. Accepts multiple subjects. Changing nature of international law. Still criticized for not expressly mentioning general principles. Other important definitions. A. J. L. Brierley. International law consists of rules and principles binding upon civilized states in their relations with one another. B. Queen v. Keene, 1876. International law is a collection of usages observed by civilized states. C. West Rand Central Gold Mining Company v. King, 1905. International law is a form of rules accepted by civilized states as determining their conduct. D. S.S. Lotus Case, 1927. International law governs relations between independent states based on their consent.